be speaking on the law making process, and I hope some of you would find the talk and the discussion interesting and related to what you are doing. First of all, I am very grateful to Devapriya and the seminar committee and the HSS department for helping me organize this talk. I am also delighted to have Pradeep sir, after long conversation and lots of persuasion, agreeing to come and deliver this talk. We are really delighted to have you, sir, here today. Also to office staff, Rubul, Durga and others for taking care of the logistic. Pradeep Chaturvedi has several decades of experience in the parliamentary procedure and lawmaking in India. He is now retired and served for many years as Joint Secretary of the Rajya Sabha, Parliament of India. He also served as an OSD to Honorable Lok Sabha Speaker and Director of the Rajya Sabha Secretariat. He was on several national and international important committees and delegation which led to a lots of new development, including National Research Foundation and such initiatives. He has also published in many reputed journals on laws and lawmaking. He has Master of Laws LLM from Delhi University and mostly work on international law, administrative law and the constitution. He is also a life member and fellow of the Indian Council of Arbitration, ICBA. Now I'd like to invite Pradeep sir to deliver his talk. He'll be speaking for about 30-35 minutes, then we can have QA. So over to you, sir.
Good afternoon to all of you. I have to be there. Okay. Sure.
Yeah, sir, you can also say.
So if you permit me to allow to speak in Hindi and English mix, or you are comfortable in English, I would have English. Okay. After lunch session is a very difficult session. Those who are sitting on the back row, they came with the purpose that we'll have a good nap because the speaker does not have the eye on them. But I am a difficult speaker. I keep the eye on the back bench only, not the front row. You will say if you want to sleep, you have to come to the back front row also. Anyway, the topic which Professor Mithilesh has said, the lawmaking process. We all see we are governed by certain laws also, but there is a tedious process behind this, covering the entire process of this particular part. India being a democratic republic, being a federal structure, in a democracy, on the republic part, if you feel that India has adopted the constitution, borrowing the principles or borrowing the best practices from different countries. At the time of independence, we are under the control of British rulers. So we have taken some part of British. We have taken the best practices of the British also, some of the US also, some European countries also. We are a mixture of best practices of various countries. In democratic part, there are two parts of a system, the parliamentary form of government and one is the presidential form of government. Both are working in different connotation, different sphere of the working of that part. India has taken the common law system. What is common law? Common law says, if you don't have any act or statutes, the apex code of the country, whatever judgment it gives, become a rule or the law for the entire country. Till a law is made. The moment law is made, Supreme Court has to follow that law. He has a right to review that law, but he cannot make a new law if the law is available over there. In a democratic part, we have three organs of governance. The organs are executive, legislative, and judiciary. These three organs administer the entire governance in the country. If you see the USA model, which is a presidential form of government, the three organs of governance are having a separation of powers, which we call doctrine of civility. they have a different separation of powers. Executive, President of USA, is elected by the public directly. He elects his own ministers, which does not belong to any of the organs, they belong to the executive organ. And that is why the President of the USA can be sued by the court of law while he is in office. Remember the case of the Bill Clinton, when he was the President of the country, he was sued for some sexual offense case, Monica Lewinsky case, and he can be sued. But in democratic part, where we follow the parliamentary form of government, here the President has been given the immunity to be sued by any of the laws. Nobody can sue him while he is in office. If you see our context, what is executive? Who are the executive in Indian context? Can someone? Okay, only Prime Minister?
And the council of ministers.
Yeah. Our constitution says the council of ministers are the executive, not the bureaucrats. Normally we see the bureaucracy as a part of it, though they are not executive. They are the council of ministers. And who are the council of ministers? They are the members of parliament. And who is legislature? Is the members of parliament. So there is an overlapping to the executive and the legislature. Only members of parliament can become minister. In the case of USA, the executive is totally different. The ministers are not members of parliament. If president wants to make a law, he has to request one of the member of his party to propose a law and make this process also. So I speak of the Indian context only when we talk about the law making process. So what is the source of law? Why law is required to be made? Since we are a welfare state, so we have to take care of our citizenship, our people, to make a certain law on certain subjects only. Main source of origination, if it is required, by change of circumstances, a new law is required. Second source of information, when countries become a signatory of any of the multilateral or the bilateral treaties, then they have obligation and go back, make a law for a particular part, like an adoption law. India having in a personal law, different religions are there. They have a different family laws also there. But India has signed a signatory of the adoption and guardianship laws 3 decades back. And for 1 decade they are unable to make a law because there are so many controversies and there are many problems over there. And then they came out and they signed the signatory, and the international community is pressurizing them to make a domestic law. What we saw, this is called a municipal law also. Municipal is not a municipality. Municipal law is a domestic law which you have to prepare it for in view of the signatories of the agreement of that law. So anything which is arising from the multilateral treaties or multilateral agreements where India is signatory of that particular part. We have a constitution which is a Bible for us. So change of requirement can make a change in that particular part. So these are sources of law which requires a government to propose a law and make a law for that particular part. And in every time something has happened which is required to be law. Now in the law-making process, all the organ having its own role to play. Constitution says it is the legislature who is responsible to make a law. Why they will make a law? Somebody will propose, then will make a law. The executive is the one who has to propose the law. On the subject, I require a law on this particular part. So we demarcate into 3 parts of it. First, what is the role of executive to do it? So it is a government which comes out with a proposal. We want a law on this particular subject or in this area. When a draft comes to the parliament, then parliament approves it. And when the parliament approves it to become a law, then the judiciary has to review it, whether it is as per our mechanism of the constitution or not. So all the 3 organs have a different role to play. For this purpose, if you have read the constitution well, in the 7th schedule, there have been 3 lists have been provided: union list, state list, and concurrent list. India being a federal system of the governance, so there are 3 layers of the governance: one at the union level, one at the level of the state, and one at the level of local panchayat. Whenever union want to make a law, that the central government want to make a law, they will make a law on the subjects which are given in the union list only. Otherwise, the federal system will be disturbed. If a state want to make a law, they will make the law on the state subject only. And then the concurrent list, where both the union and state can make a law, depending upon the requirement. If in concurrent list, a state make a law for more than 4 or 5 states made a law which are contradictory in nature, then union law will be prevailed upon all those purpose. Union government take a decision and make a law which will prevail to all states also. Like if you remember earlier the Indian Penal Code or CRPC, which is now new name has been given. The tax is the old one, but the cover is the new one. Bharatiya Nyaya Sanhita is carrying the whole old tax, altering the new numbers only. The state governments also can make some criminal amendment because law and order is a part of a state. So they can make amendments which is prevalent upon that of the states only. But if they amend any section which will be contradictory to other states also, then the law made by the union government will be prevailing upon that part. So whenever anything government decides to that, for that purpose, government has made an allocation of business rule, which is governing and dividing the work amongst all the ministries of government of India. Like Ministry of Commerce will work on the commerce and trade. Ministry of Home Affairs will work on the law and order situation and other activity in the internal security. All the ministries have been given an allocation of business rule and they have been asked to follow the union list as per the mandate given to them. So whenever they want to make law, the concerned ministry will make a proposal which is called administrative proposal, which is not in legal shape. When they all do this activity, at every stage they have to take approval of cabinet, because the executive is the union council minister. Council ministers are responsible for any activity done by union. So whenever the ministry does any make a proposal, they have to go to the cabinet to take approval, so that they have approval of the executive governance law. Second stage comes when they prepare the entire proposal. They have identified the Ministry of Law and Justice as a nodal ministry, who are the draftsmen. It consists of the 3 departments. One is the drafting department, one is the legal affairs department, which gives the advices and consultation. So one of the LD department, that is called a head drafting department, they are comprising of the draftsmen. So they send the proposal to the Ministry of Law and Justice to convert this proposal into a legal shape. For legal shape, the drafting, there are certain set principles to be followed. There should be a short title, there should be an enactment formula, there should be clause 1. If certain things are new and they have to introduce a definition, it should be a clause 2 only, and then clause 3 operate. Onwards, it's an operating clauses. So when they receive the proposal, they survey the entire literature. They find out whether this particular law or the subject is already having a law in the country or somewhere in the world also. So that if they prepare a law, it should not be contrary to the previous law also. They make a survey of the entire law making process as a drafting proposal, and they convert the draft into legal shape. And they again went to the cabinet to get it approval, because cabinet approval is required for that part. Once the administrative ministry and the law ministry comes to the fine tuning, they agree with the same proposals, then the minister should decide in which house they have to introduce the bill. It would be the Rajya Sabha also, it could be the Lok Sabha also. For that purpose, Ministry of Parliamentary Affairs is the second nodal ministry to interact with the parliament and the government. Ministry of Law is the law ministry, which is the legal shape between the ministries and the government, and the parliamentary affairs between the parliament and the government. They decide among themselves which law is required to be introduced. Once they decided that now we have to introduce in Lok Sabha or Rajya Sabha, then the Ministry of Law directly send the draft proposal to that secretariat, either Lok Sabha or Rajya Sabha. Here, the first namakaran of the bill is given, that is, it has been given the ID, which is called bill number. You all are students, you have an ID card, you are recognized by that particular ID. Now, will gets the first ID when it comes to Parliament Secretariat. Till time, government is free to make any changes on that particular part. But once bill number is given, government's role are restrictive now. They cannot make any changes without the permission of the concerned presiding officer, Speaker Lok Sabha or Chairman Rajya Sabha. And then the Secretariat goes through the entire text whether it is in conformity of the procedures or guidelines or not. If something is found erroneous, it will be told to the Law Ministry to correct it the same one and make us a final proposal to us. Once bill number is given, it's a unit number with the bill. Whether it become act or not, this bill number will remain with that bill only. Then it goes for final printing and the bills is circulated to the all members of Parliament, because as per the rules they have to get the bill 3 days in advance before it is getting introduced. Once the bill is circulated to all members, they have a right to go through the bill, read the content of the bill or the proposal. Now in parliamentary parlance we say that there are 3 readings of the bill. What are the 3 readings? That's a more important part. The 3 readings are when bill is introduced, it is the first reading. In the parliament, whatever is being decision has to be taken, it has to move through a motion only. No more decision can be taken without the motion. So there is a one motion, this is called the first reading. When the bill is listed for the introduction in the agenda paper, Minister says, I move to introduce the bill so and so. He reads the entire short title of the bill. This is the first reading where member can speak but on limited purpose. They can raise objection first on the constitutionality of the bill, second jurisdiction of the bill, whether the union government has a right to make a law or not. It is a union list or concurrent list or state list, whether we are overstepping the part of it or not, they can raise on the content of the bill on the part of introduction only. Whether parliament has a right to make a law or not. When all the members have spoken on this particular objection part, they are not supposed to discuss the bill in merits. They have to raise on the objectional part. Once it is done, minister replies and bill is introduced. Normally, when motion is moved, it has to be voted also. Voting is a voice vote or the divisional vote. And the government will be survived only when they have a majority in the floor of the house. So when the government brings the bill, naturally they have a majority. So whatever member speaks as the objection part is only for record purposes, otherwise bill will be introduced because the government has a majority to get the voting in its favor. Those who are seeing the proceedings of the house, which we have borrowed from the British rule or in our own culture also. आप कहते हैं कि 3 बार बच्चे ने ये त्रिया भाषा क्यों बोलते हैं? इसलिए मेंबर जब प्रेसिडिंग अफसर होता है वो बोलता है I think the eyes have it, I think the nose have it. Those in favor please say eyes, those in favor please say nose. Then he repeat, I think the eyes have it, eyes have it, eyes have it. 3 bidding होती है और जब ऑप्शन चलाते हैं bids 3 times. That's linked with our own cultural aspect. When you say 3 times one thing, it's become a permanent thing. So they have to repeat 3 times because they give the chance to member to raise objection. I didn't say yes. The moment they say I have it and somebody wants to say I want division, then the presiding officer obligatory to provide division. It's the voting will be recorded. Otherwise it's a voice vote. When you see the when you see the people are in the house, when the innocuous bill is going on, nobody is bothered to say yes also. They say ticket case, very heavy say yes. Somebody have to say yes, it is taken a yes also. So this is the first reading when the bill is introduced. Now this bill introduced will remain as a part of the record book. The Ministry of Parliamentary Affairs will intimate the Parliament when this will be taken up for consideration. Second stage is the bill of constitution and passing. At this stage, when the bill is listed, Minister again moves the motion that the bill will be taken up for consideration. This is the called second reading. When the bill is moved for consideration, then it is open for discussion. All the members, those who have given the name, they can speak anything about that bill, its merits, demerits, what they want to convey, they can speak the full part of it, debate. Once the debate is concluded, then the entire clause of the bill has to be adopted. It normally starts with the clause 2, because the clause 1 enacting formula and titles are adopted at the end. These are the customary part. In normal parliament say these are sun and moon, because sun rises and moon has to rise again. So these are the customary part. It will be available in all the bills. Short title, the basically name of the bill. Long title, the entire narration of the bill. And enacting formula means this is enacted in which year of the republic. These are three things which has been regularly, which has been put at the end only, when all the clauses are amended. Once the clause 2 and onwards, the members have a right to give amendments on those bills. So those bills, amendments are taken up along with the clause also. If a bill is having 40 clauses, if there is no amendment, all the clauses are put together for the vote. If there are amendments in between clauses, so those clauses will be taken up separately in between clauses, like a clause 2 having amendment, then clause 7 having amendment. So clause 2 is adopted separately, 3 to 6 clubbed together, and 7 has to be taken separately. Amendments first has to be disposed of, whether amendment agreed or not agreed. Thereafter clauses are adopted. Once they fulfill the on that part, then at the end schedules which are available has to be adopted separately, and then the clause 1 acting formula and the title are adopted. Once all are adopted, then the third motion minister moves, the bill may be passed. Bill as amended or bill as actual. This is a third reading, and third reading the member again have a right to give some inputs or intervention at that stage. So first reading and third reading are having a limited role to play, but second reading is a thorough discussion on that particular part. When the first house has passed the bill, it has to go into the second house, because both houses have passed the bill. A bill can be introduced only once, it can't be introduced number of times. For second house, the first reading will be the message reporting. When this bill is passed in the first house, a message will be sent to the second house that this house has passed the bill as so and so. Secretary General of the other house will report the message if we have received a message from Lok Sabha stating that this bill has been passed. A copy is laid. At that time, this is called first reading. Members can raise objection on that particular time also, because they have an equal right to raise objection also. And then after second and third reading, both are the same process will be concluded there. Once they complete the second reading, the house which passes the bill second or the last will send the bill to the president for assent. For the three stages, both the house has to pass and consider it, and then president has to assent it. Until the president is assented, the bill is not to become an act. After president has given an assent, now this bill gets a second name, which is called number act. You say 23 Act number 23 of 2024. It goes year-wise only. From January to December, in a particular year, whatever the bill is assented, they get the number in that sequencing only, and they become a part of a statutory book. Those bills are not considered or not passed, or they are not become an act, they remain in the part of a statutory book as a bill introduced. So the entire process of lawmaking process, the minute introduced and become an act, the Supreme Court has now full powers to review this law. The Supreme Court, as per the Constitution, has a 3 or 4 area of functional. One, original legislation, which make a law. Second is appellate legislation. Third is review legislation. Now, one of the example, the 10th schedule was added in the Constitution for anti-defection law. What was the anti-interference law? Where the members are ayaram, gayaram can be constrained. That's basically the idea of that one. In that particular clause 7 was added, the decision taken in this anti-defection law will not subject to any judicial review. Supreme Court had taken objection on that particular part. This is a basic structure of the Constitution and you cannot take any right of the review. If you want to amend basic structure, you have to follow a special procedure. What does the procedure say? You have to pass the bill with a special majority and should be ratified by 10 states. Anti-defection law was not ratified by 10 states, so they say process is not followed. So clause 7 is unconstitutional and arbitrary in nature. They struck down of clause 7. It is remain a part of it but non-operational. It has not been removed till now, in the last 42 years, but it is a part of the bill but non-operational. And all the decisions have been of the speaker have been taken care by the Supreme Court or High District or the judiciary, and they are reviewing the decision also. So Supreme Court have a right to review the entire part of it. In the lawmaking process, the interesting part, every organ has its own role to play. If the organs are not working well, although we say lawmaking process or lawmaking powers lies with the legislature, it's not true. Somebody has to come to the legislature. When the law is there, then they can finalize it. They are not preparing and they are not drafting any law. Now in Indian context, we have two types of the bills. We call the government bills and the private member bills. Government bills and private member bills, it is a typical creation in India only. It's not available in other part of the country, world. All the bills, the members of parliament have a right to move a bill. In USA, the ministers or secretary to the government cannot move a bill in the parliament because they are not a member of parliament. So they request the members. So all the bills in USA are the private member bill. With the support of government, it is being created. In India, whenever the government wants to bring a bill, the minister is the member of parliament, he can move a bill. So we have give a terminology, government bill or the private member bill. That the members who are not the government, who are not the ministers, the bills moved by them are called a private member bill. Other bills which is moved by ministers are called the government bill. In the parliamentary form of government, there are two unique difference between the UK and the India. In the UK, member of the one house, whether he is a minister or not, cannot go to the other house. Prime Minister of UK cannot defend any action in the House of Lords, who is a member of House of Commons. He will request other ministers of his cabinet to defend the action taken by him. But in Indian context, that's why they have modified the best practices. They have allowed all the ministers, whether he is a member of the Lok Sabha or Rajya Sabha, can attend both the houses. The benefit in the lawmaking process, minister who is thorough with the subject matter, he knows the ins and outs of it, he can defend the bill better in both the houses and can justify the need of that particular part. Now the question arises, what happens to the private member bill? What is the purpose of it? Is the right of a member, he has to move a bill, and in the 70 years of history, we have only 14 private member bills which have become an act. Government does not have an idea sometime to bring a bill, or the local requirement, or the requirement of a particular cluster. These private member bills gives an idea to government also, it is a need of the time, we can bring a new law. So when the private member or the members bring a law or bring a bill, introduce a bill, it gives idea to the government. And then government can keep on thinking of making a law in that particular part. Latest example was when this LGBTQ movement was on the peak, one of the private members was introduced in Rajya Sabha on the transgender's rights bill. In the Rajya Sabha, the government was not in majority and the bill was get passed, which was rarely, which is not happen so easily, but it was get passed in Rajya Sabha. And it is transmitted to Lok Sabha to consider it. Since the Rajya Sabha member cannot come to Lok Sabha, he requested other member to get the bill pilot in the Lok Sabha and get it passed. And the fortunate part of the member, his name also came in the ballot and he selected that bill as the first bill to be considered. And when the bill was taken up for consideration in Lok Sabha as a private member bill, then government has started negotiating with the member or making different aspects of it. They want to understand that the provision of the bill which member has drafted having some limitations on that part. But government will bring a bill, they take care of the entire aspect of that movement or the transgender rights also. Member was made convinced if you can hold this bill, government can bring a bill considering and consulting you also and covering all aspects thoroughly. And government took 2 or 3 years to come out with the transgender bill, and that will remain on hold for that much of period. And when the government made the act on transgender bill, then that bill was withdrawn at the later stage. That means these private member bills look like innocuous kind of some documentation in the statute book, but it actually creates an idea. The private members, the members who proposes a bill, if he has come out with a good ideas, these ideas can be seen easily also. Do I have
5 minutes, sir.
for me?
For 5 minutes.
Now, as a researcher or as a students, if you want to see the entire part of it, you can visit the website of Lok Sabha Rajya as a repository of all information. This information will be much useful for you to understand how this process is going on. As a researcher part, I have 2 poses for you before we take up question and answer. One, till now, there is no mechanism to understand the impact assessment. What is impact? How it is going to influence the society at large, our economic condition, our judicial system, our environmental part. There is no mechanism for that particular part. Because when you go through a bill, you always look for that edition of the bill, that version of the bill which is as introduced in the house, which contains certain pages, which is not a part of a bill, but it's information. When initial stages, it was carrying only an SOR, statements on object and region. If you want to understand the context of the bill, you must read the SOR. It gives you why this bill is proposed and why this law is required to be made. It is available only in the as introduced bill. It is not available as passed or as. There are 3 versions: to be introduced, as passed, as assented. 4 versions are there. To be introduced, the slightly risky one because there could be some changes at the initial stage of that. As introduced is the final version. No changes can be made on that particular part. It contains SOR. It contains financial memorandum. If it is a fresh bill, it contains the notes on clauses also. It gives you a fairly good idea to what actually the bill proposes to make a law of that particular part. These all our guidelines are coming as per the requirement has come over there. Now, for the LIA, for impact assessment, there is no guidelines as of now, and the government has to bring some kind of mechanism to make this impact assessment must require for it. You all aware of the one law made, amendment of the Legislative Instrument Act, Section 39. 3 clauses were made, amended, and a new law is made, which made the check bouncing case a criminal offence. Small amendment, small bills, no much of the impact on that part. Initially, the courts were asked to handle the criminal offences of cases. One court in every district is required to make the provision for that. But presently, 35% of pendency of cases belongs to this. 4 or 5 courts are working without any alternate arrangements. If the 5 courts are busy in the check bounces cases, so what happens to other cases? It's remain pending list. If we take some mechanism on the check bouncing cases, our mechanism will change. 35% cases will be disposed of. Out of these 35% cases, 90% case belongs to 5 lakh rupees or less. I give 20,000 rupees check to Mithilesh, it get bounced. मुझे सबके पास होती हैं, होता ही है. कोर्ट में लड़ाई करेंगे जाके, जीत के आएंगे कोर्ट से. Just forgetting one fact, 20,000 की रिकवरी के लिए 1 लाख रुपए ये खर्च करेंगे वकील के ऊपर, 1 लाख मैं खर्च करूँगा. कितना खर्चा हुआ? 2 लाख रुपए. और कोर्ट में कम से कम 10-12 हियरिंग होंगी. 4-5 लाख रुपए कोर्ट खर्चा करेगा उसको सुनने के लिए. फॉर रिकवरी ऑफ 20,000 रुपीज अमाउंट, वी स्पेंड 1 lakh each of individual amount and 4 lakh of precious government amount. This impact was never assessed earlier. Why we need to go to the court for this petty amount? Check bounces cases, the amount has to be fixed. Like in you see in that particular part, this consumer redressal forum created. What happened to that one? District court, this amount of purchase, you go to district court. If this amount is purchased, you go to the state court, and if you go to the part of national forum. The idea was lawyers should not be allowed. Sorry, I am also from that faculty also. But lawyers should not be allowed to appear in these forums or tribunals. But gradually lawyers snip into. And recently National Forum has given judgment with a 10-year-old case. So our alternate system of redressal has also become a normal judicial procedure also. If you don't understand the impact assessment, same thing happened to arbitration. You find all the visiting card of lawyers, it's written over there, expert in arbitration. Arbitration lawyers are not required at all. This arbitrator sitting over there, 2 parties sitting over there, let them decide it. What the lawyer is doing it? It's now become a change scenario. Arbitration become a parallel court to decide the things also. Decisions are being delivered after 6 or 7 years. Pendency are increasing it. So, impact assessment, if you want to take up a subject on that particular part, it is an ideal part. So we can give certain mechanism and guidelines, suggestions to the government. When a law is made, we must have an impact assessment of the part. What impact is going to have, economical part, what is judicial impact. There are 7 kind of impact. So these are 4 areas which I was working as a committee, secretary, committee on law justice, as a parliamentary committee, I am in charge of that committee. One is ADR issue, one is the impact assessment issue. And this is required to be handled that. Thank you for patience. If you have questions for me.
So here we had a very informative talk. So any question, comments you would like? And sir has wonderful experience and very long experience in the parliament. So as a researcher, if you want to know something that is beyond you, beyond the talk today, you can also ask him as to when he says about the regions of the bill. ROS, region of a statement, how to access that and all kind of question. So you feel free to ask it. Yes.
Thank you, sir, for the insight. Sir, I have 2 small questions.
Yeah, please.
Sir, I want you to understand the mechanism through which chairman decide on the issue, means the fate of notices served under the rule of 267. And what what is the role of the spirit of the ruling party or partisanship on this? And my second question is related to this. When we saw the legislature through the lens of executive accountability, we saw that the accountability mechanisms which has been given to the legislatures is depleting day by day in the sense of limited period of running of parliament, quality of debate and all. So whether you see it as our collective societal failure or the lack of political will kind of thing.
What are you doing, PhD or are you doing PhD? What's the subject of the PhD? Actually, I have two political questions to me. I could not have answered these questions 1 year back. Now I'm a free man, I can answer those questions much effectively. The first question is the notice of 267. Have you read the 267?
Yes, sir.
Have you read the rule number 267?
So a little bit what I got from that thing means if a member of Rajya Sabha gives the notice to the chairman in advance 3 to 4 days before, so chairman has to decide over it.
You have read the newspaper clipping, not the rule.
Sir,
I advise you to go see the text. See, being a law student, I did my masters of law. I am a firm believer of one thing. Please read that Bare Act before reading the commentary. Commentary is the alteration and addition of the mood of the people over there. Bare Act remains the same. You have to interpret the Bare Act. One of the old draftsmen, which is the election commissioner also, Inspector R.B. Peri Shastri sir, he used to say, when I put a comma in a draft, I think for 3 days what impact is going to make it. Because there are 4 words, roko, mat, jane, do. Comma makes an impact. Roko, mat, jane do, roko, mat, jane do. Are negative and positive. So one comma makes a law much different from that part. 267.
You can
267, there is no adjournment motion in Rajya Sabha. Reason? The Rajya Sabha is a council of states. It is not the house of people having the same power which Lok Sabha having. So in government having accountability in the house of people. The constitution says they have to enjoy majority throughout their tenure. We have a fixed tenure of the Lok Sabha, but not a government. Government can be for 1 day or can be for 5 years. The moment they lose the majority in Lok Sabha, the government is collapsed. So they had made a provision of adjournment motion. There are certain type of motions which makes the accountability to the government, to the parliament. So adjournment motion is the one motion where they want to adjourn all business and then take up this part which is crucial. And motion, when the motion is there has to be voting. The difference between motion and discussion only verbal diarrhea, nothing else. Motion is required, whether you discuss or not, you have to get voting. And the voting is the area which gets the decision of the government part. In Rajya Sabha, they had made a clause, rule 267, which is not anything else than the Lok Sabha, which says they can give the way to suspend the business of the house and take up some discussion. The two things. Suspend the business of the house for what? To take up something. Now to take up something, the rule says it should have a speaker, permission of the chairman also. Now I want to discuss the price rise. Chairman has not given permission to discuss the price rise. How can I move the motion again to rule 67 to suspend the business to discuss price rise? First I have to take a permission of the chairman to get subject approved. Then I can move motion for the order. But that's the problem. To 67 motion, they are giving the intentional part to get the highlight because the issues are being raised. But it requires the permission of the chair. Chair has not permitted to raise any subject. How can you suspend the business which is yet to be approved by chairman? To suspend the house, to raise a discussion. And to raise a discussion, they need a permission of the chair, which is yet to be given. How can you raise a motion to suspend the business when there is nothing to discuss? Now, if Mithilesh are coming, you suspend your classes to take up my class, and my class is not approved by HOD. So how can you make a suspension of the class? First thing you have to get my class to be approved, then you can raise that now your class is already suspended. Same thing, that's a problematic area, and see, in politics, everybody has right to speak, everybody has right to make their own viewpoint. Chair decides what the rule says. So 267 they want to compare with the adjournment motion. In adjournment motion, I was with the OSD with the honorable speaker. Same issues were rising. Every day we are getting 10 or 15 motion. Since the rules are given, so they can have a right to give the motion, and the speaker will dispose it off. Earlier he used to take the name of all the, then later on say, right, so why you take the name of all? They say, I have received these number of motions and I have not approved it. I have not approved it. And again this was discussed on various forums. In Congress party at the time, the three members are giving three different reasons for adjournment motion. It was asked to them to decide amongst your party which motion you want to move. You want to move three of motions. You want to have options for that particular part. ऐसा आता है कि वो आप जाए वहाँ पर कफन मांगने के लिए कि साहब उसमें कुछ कलर दिखा दीजिए वहाँ पर कफन तो सफेद कलर का होता है. That means you have a motion only for one. You have a one teaching subject. You have one motion. All the members should give that part also. We have a 10 motions having a 10 subjects. You're giving the right to the speaker not to allow that particular part. The second part of yours. The condition is deteriorating it, not in parliament, everywhere. In academic institutes also. When I was a student, we have to break through the lecture halls to attend the session of the invited lecturer. Now after COVID, nobody wants to come out from the room or never come from the house. They all want to have a cozy, because they have been scared, not scared, they were kind of lazy and artsy. Because we have some facilities to be done. So deterioration is universally everywhere. I don't know from where you have taken this particular part. Accountability mechanism are at different aspects of it. One, bill is referred to a committee. The committee examines thoroughly. They are hearing the stakeholders also. Then they give their report. Although it's not binding, but government is compelled to take decision on that particular. They can't ignore it. Then the decision comes over there. Now, those bills which are getting passed, it's basically majority with the ruling party. Like this Bharatiya Nyaya Sanhita, these all have been passed. Government having a majority, they have their own say. Even though opposition make a hue and cry, nothing much will be happen in the particular part, because they can get the voting done in their own favor also. But they make their impact. So sometimes your voice is also important. So register the dissent and get the things done. I will give an example of the one. Recently we have passed a mediation bill. I was in charge of the committee, and the mediation bill was referred to that committee. And we had a good lawyers as a member of the parliament in that committee. We made the recommendations in such a way, because having a drafting lacunas also, it's having the overriding effects also. This one section says about pre-litigation mediation is a mandatory now, and they define the pre-litigation mediation. That given the 3 or 4 clauses, 5th clause says any case which is filed in the tribunal or the court of inquiry or the commissions can also can be filed for mediation. The question was raised, when the person will go to tribunal, how can you call it pre-litigation mediation? Litigation is already there. You have to put separate clause. There are so many variations over there, and after the amendment of the report of the committee, this report was given by me, government has brought 108 amendments in the bill, 108 amendments. So accountability is completely fulfilled over there. If this bill has to go in that shape, it is very difficult to manage that particular part. Last part, which is again a political question, because of Halla Gulla. What we see, it's a perception. Because somebody wants us to see from that perception only. Yes, agreed. Halla Gulla is there. And for that why the parliament is made. Opposition is to make it their own voice, to ask for that particular part. But you forgotten one aspect of it. Every day in Rajya Sabha, 175 questions are asked. In Lok Sabha, 250 questions are asked. Whether house functions or not, government has to prepare answer for that questions. And it's become published on the website. That means that members are raising the public views or public representation through those questions, and government is working on those questions also. The impact of parliamentary question, that government has to answer those questions effectively. There are two things, RTI or parliament question. RTI government tend to avoid the answer. In parliamentary question they want to give more answers because they should not face the privilege part. I can say you one instance of this parliament question impact of it. It was never discussed on the floor of the house. No debate was made. One member asked the one question, how many cases of the passport issuing pending in one of the regional passport office. At that particular day, there are 800 applications were pending, and it was pending for the period from 6 to 8 months back. And when the answer came, the pendency was only for 5 days, only few applications were pending. They worked in 8 days and issued all passports within that time period. That's the impact of parliamentary question, because they want to clear their own image. It's all depend upon which question you are asking it. If you are not asking good question, you are not getting a good answer. A small stance of yours. एक नेताजी अपनी गाड़ी में जा रहे थे, सॉरी आई हैव टू से इन हिंदी ओनली. एक गांव के पास गाड़ी रुकी, उन्होंने पूछा मैं कहाँ पर हूँ, तो गांव वाला था आप अपनी कार में. बोले कार कहाँ है, बोले कार सड़क पे है. ये सड़क कहाँ जाती है, वो सड़क कहीं जाती नहीं है सर, आपकी कार जाएगी, सड़क यहीं रहती है. अब गुस्सा नेताजी को आया कि मैं पूछ रहा हूँ कि गांव का नाम क्या है. बोले सर क्वेश्चन का पहले आपने क्वेश्चन पूछा है, तो आप क्वेश्चन बेवकूफ़ी क्यों पूछ रहे थे, मैं आंसर ऐसे दे रहा था. गांव का नाम ये है. इफ यू वांट टू हैव अ रियल इम्पैक्ट, you have to good question to be asked. If you ask a ambiguous question, you will get the ambiguous answer also. You cannot get a good answer. Your questions are in that category only. You want to put me in a political part, but had it been a year earlier, I could have dosed the question also. Today I have a free man, I can answer the question easily also. Anyone else?
Yeah. Anyway, so what we can do, so it's already close to 4.
Oh,
Maybe 5 to 10 minutes we can maximum spend. Do you think? Do we have any question on the YouTube also?
No.
You can check them. But meanwhile, we can allow 2, 3 questions. You can take them together, sir, right? Any more questions? Yes.
I want you to reflect on the idea of ordinances and how
can you speak clearly?
yeah. And I want you to reflect on the idea of ordinance, that how it draws the parliamentary procedures, and these days it is used to actually draw all the nomination processes and laws implicated instead of being published in parliament. It is right to publish.
Anyone else? Any more question? Yeah, please.
So, like, if the government is in a majority in both the houses, the bills get passed in a good pace. Like, there is no blockage or anything. But when the government is, say, not in majority in one of the houses, mostly in, say, Rajya Sabha, so the bills get stuck. So, according to you and with your experience, what will you say that which is better? Like, when bills get passed wisely, or maybe is this stuck over time and is delayed?
Ordinance, in law, everything is made for the good. And we, the Indians, are very good in making a loopholes in the good also. You make a new brand, Philips has made a new radio, and the day he released, he found that the dummy is already made in the market and flourishing it. The only spelling difference is the double L. Double L, double P. So trademark is not violated. So he made that, and you read the spelling as a Philips only. And the market was taken over by Philips. So ordinance is a good mechanism given, it's checks and balances. And that's why it has been given the power to the parliament. If the moment parliament is summoned, you have to get it approved within 6 weeks of time. Otherwise, you have to re-promulgate it again. Bihar was doing it for years together. Now, Central is also doing it because they will follow the best practices much earlier. Second part of your question, see, it's a duty of the government. If I am authority, it's my duty to take everyone in field. If I don't take it, then it's my failure. Earlier governments, whether they are majority or not, they take opposition members in their own confidence. Minister of Parliamentary Affairs is supposed to be the face among the parliament to manage the floor and take the opposition leaders in confidence. So no bills was stopped earlier. If the arrogance comes or if the discussion are not being held, deadlock is made, then it's become of the question of their own impact. Yes, who is the bigger? And that's why Rajya Sabha has faced number of the bills referred to select committee. And then later on they are passed also. But it was delayed. So it's a political question. Let it remain to politics. You should not go into that particular part. It's a own dimension of politics. Whether I want to survive this political party or not. But if the parliament or government wants, they can manage anything. Vajpayee ji, Pranab Mukherjee ji, these are the legendary people who made the parliament function. It's a real true issue. They have not taken their own issues to the parliament. They have taken the national issues to the parliament. And bills can be passed easily also. Sometimes bills are having a deficiency and it's required to be discussed and debated also. And few bills have been passed, like RTI. You know, RTI when it was passed, it has brought 176 amendments. Because the left party was supporting the ruling government, and they brought those amendments, and the Ministry of Law unable to vet those amendments, resulting into there so many loopholes in that bill itself. Act now. Because you amend one section, it has a repercussion in the 5 other sections also. You have to amend that 5 sections also. So one amendment moved in one section, remaining part is left over. That's a problematic area. It's a hardship we have to face. But it's not a big issue which cannot be handled also.
You got the answer? Alright, so I think we can now conclude. Over to you, Duly.
Thank you so much, sir, for this wonderful talk, and I hope our students have benefited greatly from this exchange. Thank you so much. We would love to have you back.
Last time.